Hello students, welcome to EPG Pathshala. I am Dr. Vageshwari, teaching at the Faculty of Law, University of Delhi. Today, we will be discussing the module titled Crimes of Obscenity, Stalking and Voyeurism. This module is a part of the paper Women and the Law as a part of the discipline Women's Studies. Let us have a look at the objectives of this module. The main objective of the module is to provide introductory knowledge to the readers now how seemingly harmless acts such as following someone, showing pornographic content, or viewing others in their private acts constitute criminal behavior under the law. The other objective is to make the readers aware of the criminality in these acts, the fact that these are acts that can be complained against, and these are acts which are punishable under the law. We will also try to gain an insight into legal provisions against obscenity, voyeurism and stalking provided under different laws in our country. To begin with, let us try and understand what is stalking. Stalking is an unwelcome intrusion into another's privacy. There is an unwanted or obsessive attention by the accused that pesters, intimidates, or causes harassment to the victim. Now, this sometimes assumes frightening proportions when the stalker resorts to threats or violent measures that intimidate the victim. Stalking causes mental harassment to the victim and might lead to disruptions like changes in employment, residence, and phone numbers. Cyber stalking is the use of computers or other electronic technology to facilitate stalking. In cyber stalking, victims are targeted through electronic and online means. This might include hacking computers, installation of hidden cameras, microphones, installed tracking, and monitoring software. Sometimes very seemingly harmless activities, sometimes those acts which are apparently very harmless, they might also create some kind of a fear in the victim. Like you just go to your Facebook profile or you just open your WhatsApp account and someone suddenly starts bombarding you with messages. Writes, "Hi, how are you? I saw you at the cinema the other day. You were wearing this dress. You were looking very beautiful." Now, the victim is shocked. Now, this is not what she was expecting. She had not anticipated that someone was observing her all the while. And sometimes when she is not interested in talking to someone, the other person is consistently and persistently bombarding her with messages. This is all a violation of her space. All this amounts to stalking, and this might create a sense of violation of private space in the victim. Let us understand what stalkers do, what goes on in their mind. Stalkers are so obsessed that they monitor their victims online or physically, irrespective of clear disinterest of their victims. They suffer from psychological problems such as schizophrenia, delusions. Stalker's motivations could be varied. He might be looking at revenge, settling some old scores. He might be desiring some company. The motive could be sexual pleasure. It could be anything. Stalking involves repetitive behavior or a series of actions such as phone calls, messages, emails, and sending gifts that occur over a period of time. In fact, there is a psychological problem which has the name of erotomania. In these cases, stalkers have a false belief that their victims love them or that the victims, they need rescuing it. Let us have a look at the laws against stalking in our country. Section 354D of the Indian Penal Code, which was inserted in the IPC by the Criminal Laws Amendment Act of 2013, defines stalking as follows. It says, any man who follows a woman and contacts or attempts to contact such woman to foster personal interaction repeatedly, despite a clear indication of disinterest by such woman, or monitors the use by a woman of the internet, email, or any other form of electronic communication, commits the offence of stalking, provided that such conduct shall not amount to stalking if the man who pursued it proves that it was pursued for the purpose of preventing or detecting crime, and the man accused of stalking had been entrusted with the responsibility of prevention and detection of crime by the state, or it was pursued under any law or to comply with any condition or requirement imposed by any person under the law, or in the particular circumstances such a conduct was reasonable and justified. Section 66A of the Information Technology Act provides usage of computer resource or any communication device for sending offensive information or false information for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, or ill will, persistently, or to deceive or to mislead the addressee or recipient about the origin of such messages is punishable with imprisonment for a term which may extend to 3 years and with fine. Now students, as you can see in the slide, stalkers, they derive encouragement from the silence of the victims. Perpetrators feel safe when they know that their victims will not name them. So, we need to stop it. You need to know it. You should have a zero tolerance. Don't tolerate it. Name it and stop it. It is real. It can happen to anyone. Stalking can consist of any persistent or unwanted behavior which causes anxiety, harassment, fear. But the question is, can you take back control? And the answer is yes, you can. More often than not, stalkers have a desire to isolate the victim so that the victim has no one but the stalker to turn to. And that is the reason they persist. They deliberately try to defame the victim, spread false rumors about the victim so that others who would care about the victim, they draw a distance from the victim. These are all steps towards isolation of the victim. Next, let us understand what is voyeurism. Now, voyeurism is a psychosexual disorder in which a person derives sexual pleasure and gratification from looking at the naked bodies and genital organs or observing the sexual acts of others. Now this term, it has come from the French term voyeur. Voyeur, which means one who looks. Male voyeur is commonly labeled as peeping Tom. Voyeurism is a form of abnormal sexual behavior and non-consensual voyeurism is a form of sexual abuse. Usually voyeurs, they do not involve with the subject directly. The essence is observing. They may use techniques like peepholes, hidden cameras, two-way mirrors. Many countries have expressly declared voyeurism as a crime by enacting suitable legislations. Voyeurs, they derive some sort of a pleasure by observing others in their intimate acts, for which they might like to sneak a view they might like to see through some kind of peepholes or cracks in the doors or some holes in the doors in the walls. Let us try and understand the law against voyeurism. Section 354C was inserted in the IPC in the year 2013, which reads, "Any man who watches or captures the image of a woman engaging in a private act in circumstances where she would usually have no expectations of being observed by a perpetrator or any person on behest of the perpetrator. When such person disseminates such image, he shall be punished on first conviction with imprisonment for a term which shall not be less than 1 year, but which may extend up to 3 years, and shall also be liable to fine. On the second or subsequent conviction, such imprisonment shall be not less than 3 years, but it may also extend up to 7 years and shall also be liable to fine." Now, explanation 1, it clarifies that for the purposes of this section, private act includes an act of watching which is carried out in a place which in the circumstances would reasonably be expected to provide privacy and where the victim's genitals, posterior or breasts are exposed or covered only in innerwear, or when the victim is using some kind of a lavatory or the victim is doing a sexual act that is not of a kind ordinarily done in public. Where the victim consents to the capture of the images or the act, but not to their dissemination to third persons, then such dissemination will be an offence. Section 66E of the Information Technology Act 2000 provides punishment for violation of privacy. Under this section, if anyone intentionally or knowingly captures, that is, videotapes, records, photographs, or films in any way, or transmits the image of the private area, that is, the naked or undergarment clad areas of human anatomy of any person without his or her consent under circumstances violating the privacy of that person, then such an offence would be punishable with imprisonment up to 3 years or with fine up to 2 lakh rupees or with both. Such a provision was needed to counter the menace of installing hidden cameras in changing rooms in shops, in public urinals, in hotels, rest houses, rented houses, and even paying guest accommodation. There are frequent cases involving girls whose pornographic pictures are taken by their boyfriends and then circulated via MMS or uploaded on the net, bringing great disrepute to them and their families. This provision will prosecute such offenders. The provision under IPC is particularly helpful as now merely observing a woman in private act without recording the same has also been made punishable. Now, this will deter peeping toms from lurking around women's toilets and change rooms, and this will accord more privacy to women. What amounts to obscenity? Obscene is offensively or repulsively indecent. The word obscenity denotes something which is offensive to modesty or decency, which is filthy and repulsive. The law tries to prevent obscene behavior. That is one which is contrary to the moral and aesthetic sense of society. However, what is moral and what is not remains difficult to specify because what may be unaesthetic in a given situation may not be the same in a different situation. Obscenity in cyberspace. The nature of internet is such that it is very difficult to regulate it. On net, everybody has easy access to all sorts of materials. Obscene matter posted or transmitted through internet can traverse many jurisdictions and can be accessed in any part of the globe. The existence of pornographic material on internet has been a matter of concern, and even the most stringent restrictions on the publication and dissemination of pornographic materials on the internet have not been able to control it. Daily, new and less detectable measures of distribution of pornographic stuff are evolved, which pose a grave threat to the privacy and sensibilities of the users, especially belonging to the younger segment, that is, children and teenagers who are more vulnerable and susceptible. Now the question is, what matter is obscene? For its determination, the Supreme Court of the United States issued the following tests in Miller versus California. The test was whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest, whether the work depicts or describes in a potently offensive way sexual conduct, whether the work taken as a whole lacks a serious literary, artistic, political, or scientific value. The test of obscenity under the Indian law has been borrowed from English law. In the Old English case of Hicklin, it was held that obscenity should be such as has the tendency to deprave and corrupt those whose minds are open to such immoral influences and into whose hands a publication of this type may fall. The Indian Supreme Court adopted national standard to determine obscenity, but the American Supreme Court reaffirmed in Miller versus California the test propounded in Roth versus US that local community standard should be taken into account for determining obscenity, because a national account for determining obscenity is hypothetical and difficult to ask. The question arises, whose community standard or national standard will determine the nature of the matter? Is it the standard of the place of origin or the place of destination or any place through which the material traversed? In United States versus Thomas, the court held that it is the community standard of the place where material is accessed and not the place of origin which would determine obscenity. The community standard varies from place to place and country to country. To avoid stricter community standard, the defendant must deny access of material to the person of the community. The court also asserted that there is no need to carve out a new definition of community for online obscenity cases. Sections 292 and 293 of the Indian Penal Code 1860 deal with sale, etc. of obscene books and obscene objects to young persons. Clause 1 to Section 292 explains specifically the connotation of the expression obscenity. Clause 2 of the section punishes a person who sells or in any manner conveys publicly the obscene books or any other material of the same effect. The section makes exception in respect of any representation, sculptured, engraved or painted, or in any ancient monument, where a person is charged for having been in the possession of an offending book. An offence under this section would only be constituted if possession of the book was for the purpose of its sale. The court has power to call for expert opinion under Section 45 of the Indian Evidence Act 1872 when it has to form an opinion on any such matter. Section 293 of the IPC provides for enhanced punishment to those who sell, distribute, exhibit or circulate any obscene object to persons under the age of 20 years. Section 294 of the IPC lays down that whoever, to the annoyance of others, does any obscene act in public place or sings, recites or utters any obscene songs, ballad or words in or near any public place shall be punished with imprisonment of either description for a term which may extend to 3 months, or with fine, or with both. This section requires that the obscene acts mentioned under Clause B must be done in or near a public place. Indecent exposure of one's person in bus, metro, or public transport, or urinating publicly at a place where it is likely to be seen by others are offences falling under this section. Similarly, sexual acts in a public place will be punished under this section. Thus, for an act to be punished under section 294, it must cause annoyance either to a particular person or persons in general. The words "to the annoyance of others" do not limit it to mean the person who is the intended victim of the obscene act of the accused. Section 67 of the Information Technology Act 2000 makes it an offence to publish, transmit, or cause to be published in electronic form any material which is lascivious or appeals to the prurient interest or tends to deprave and corrupt persons who are likely to see, read, or hear the matter contained or embodied in it. The punishment provided is imprisonment and fine. On the first conviction, it is up to 3 years and up to 5 lakh rupees. On the second, up to 5 years and up to 10 lakh rupees. This section also applies to the publishing and transmission of obscene material and covers a website, email distribution, and also a digital rendition on a CD. Section 67A of the Information Technology Act, inserted by the IT Amendment Act of the year 2008, prescribes punishment for up to 5 years and in cases of subsequent conviction up to 7 years, and also with fine up to 10 lakh rupees for persons who publish, transmit, or cause to be published or transmitted in electronic form any material which contains sexually explicit act or conduct. An offence is committed when the material is disseminated through the mode of publishing or transmission, even if it is done for private use only. Another section that was inserted by the Information Technology Amendment Act of the year 2008 is Section 67B, which lays down punishment for publishing or transmitting of material depicting children in sexually explicit acts in electronic form. This provision seeks to keep a check on pedophile activities. In law enforcement, the term pedophile is generally used to describe those accused or convicted of the sexual abuse of a minor. Section 67, 67A, and 67B of the amended Information Technology Act specifically exempt from prosecution for cyber pornography any book, pamphlet, paper, drawing, writing, painting, representation or figure in electronic form, the publication of which is proved to be justified as being for public good on the ground that such book, pamphlet, paper, writing, drawing, painting, representation or figure is in the interest of science, literature, art, or learning or other objects or of general concern, or which is kept or used bona fide for religious purposes. Indian Parliament in the year 1986 passed an act entitled the Indecent Representation of Women Prohibition Act. The object of the act was to prevent the depiction of the figure of a woman in a manner which is derogatory or denigrating to a woman, or which is likely to corrupt public morality. Section 3 of this act lays down that no person shall publish or cause to be published or arrange to take part in the publication or exhibition of any advertisement which contains indecent representation of women in any form. Section 4 further lays down that no person shall produce or cause to be produced, sell, let or hire, distribute, photograph, representation of figure which contains indecent representation of women in any form. Art has such varied facets and such individualistic appeals that in the same object, the insensitive sees only obscenity because his attention is captured not by the general artistic appeal or message which he cannot comprehend, but by what he can see. The intellectual sees beauty and art, but nothing grows. To determine obscenity, overall view of the entire work is to be taken to see whether the obscene passages are so likely to deprave and corrupt those whose minds are open to such influences and in whose hands the material is likely to fall. In doing so, one must take into consideration the influence of the material on the social morality of the contemporary society. In the motion picture Bandit Queen, some of the scenes were considered obscene by Delhi High Court, but the Supreme Court did not agree and the film was exhibited in several cinema houses. On screen, you can see the poster of this movie Bandit Queen. There is a very close relationship between obscenity and art. For some, a work of art might appear obscene and others might choose to see only art in the same. So students, in today's module, we tried to understand what amounts to obscenity, what is stalking, and what is voyeurism. Here, it is important to point out that our behavior is reflective of our values and morality. Socialization has an important role to play in it. In our society, boys, since their childhood, are conditioned into believing that girls are shy and coy and hesitant to express their feelings, and that boys are supposed to be aggressive and take the lead in any relationship. Thus, their conditioning doesn't allow them to take no for an answer. They persist in following girls under the impression that the girl also likes him and is just acting pricey, and a little perseverance on his part will eventually get him the girl. This causes him to stalk her, and little does he realize that his act has actually transgressed into criminal territory. Here, our media, films, serials, etc. have a very important role to play in dispelling these old notions. But more often than not, they reaffirm these beliefs. What do our movies show? Seldom do we come across meaningful cinema. Similarly, we seldom complain about obscenity. We often see men urinating publicly. Do we ever complain? No, because we are accustomed to such sight. We don't know that such an act can be complained against, and most importantly, we have the capacity to ignore. But let us realize that obscenity, stalking, and voyeurism cannot be and should not be tolerated in a civilized society. We need to be responsible for the safety and welfare of society. We cannot allow the interests of few to outweigh the safety of the majority. Thank you.